Hello everyone, welcome back to our RR Legal Talks. Today we are discussing on Section 34 of Companies Act 2013, criminal liability for false prospectus, jail and fine under Section 447. Misleading prospectus. Just it is not a mistake, it is a crime. Section 34 of Companies Act 2013 imposes criminal liability on those who authorize a prospectus containing untrue or misleading statements. In this video, we explain how such violations can attract imprisonment and heavy fines under Section 447 and what promoters and professionals must do to stay proceed. So, what constitutes a misleading statement? Who is liable? Directors, promoters, professionals. How to avoid liability? Linked to Section 447 punishment for fraud. Real implications for IPOs and public offers. These are all we will discuss in this video. What is Section 34 all about? Section 34 states, if a prospectus contains any untrue or misleading statements, or if any inclusion or omission misleads investors, then every person who authorizes the issue of such a prospectus is criminally liable under Section 447. So, who can be held liable? Promoters liable. Directors named in prospectus are liable. Company secretaries involved in drafting, legal advisors and merchant bankers, any person who authorizes the issue, merely signing the prospectus or approving it in the board meeting can be treated as authorizing its issue. So, what makes a statement misleading? An untrue statement, factually wrong, a half-truth, technically correct but misleading in context. Omission means not disclosing the material facts that an investor needs to know. Even an honest mistake can attract liability if due diligence was not exercised. How can you avoid criminal liability? Under the proviso to Section 34, a person is not liable if he can prove the misstatement or omission was immaterial or they had reasonable ground to believe and did believe till the issue that the statement was true or the inclusion or omission was necessary. This highlights the importance of documented due diligence, professional opinion, and audit trials. So the punishment under Section 447, fraud cause. If found guilty under Section 34, you will be punished as per Section 447, which can include imprisonment minimum 6 months up to 10 years. Fine not less than amount involved in the fraud may extend to 3 times of the amount involved. If public interest is involved, then minimum imprisonment is 3 years. This is not a civil penalty, it is a criminal fraud with a real-time jail. So the best practices to stay protected is ensure every statement in the prospectus is backed by evidence. Vet the draft through legal and financial professionals. Maintain documentation of all opinions and reports. Always err on the side of the full and fair disclosure. Include disclaimers and risk factors very clearly. A misleading prospectus is not just a compliance lapse. It is a potential criminal offense under Section 34. Be cautious, transparent, and thorough. Your reputation and your liberty may depend on it. Subscribe to our channel for more legal compliance tips and key-based insights into the Companies Act, SEBI regulations, and corporate governance. RR Corporates and RR Legal Talks, two channels. Please do subscribe RR Corporates and RR Legal Talks for more updates. Hit bell icon so that you will not miss any of the latest updates. Thank you.